Hello friends, welcome to Jurist Lens. Today we are subject to discuss intellectual property rights. This is sunrise of knowledge. 17th century known as the era of scientific revolution. 18th century known as the era of political revolution. 19th century known as the era of industrial revolution. 20th century known as the era of information revolution, and 21st century known as the era of knowledge revolution. Now let's understand what is intellectual property. Intellectual property refers to creation of the mind that are protected by law. These creations could be inventions, designs, names, symbols, artistic works, and other forms of expression. The aim is to protect the intangible creations that result from human creativity, effort, and intellectual labor. So the word intellectual refers to the use of human creativity, knowledge, and innovative thinking to create something original. So the word property in its broadest sense refers to anything that is owned by an individual, group, or entity and can be controlled or disposed of as per the owner's discretion. Traditionally, property has been classified into two main categories. Number 1, movable property, and number 2, immovable property. Movable property includes tangible items such as vehicles, jewelry, and personal belongings. Immovable property refers to land and anything that is attached to it, such as buildings, infrastructure, and natural resources. So here, intellectual property is intangible property. It exists only in the form of ideas, inventions, or expressions of creativity. This is why IPR is seen as a way of protecting the intangible assets that creators, inventors, and companies produce. Now let's understand what is intangible property. Intangible property refers to assets that do not have a physical form but still have a value and are legally protected. Intangible property includes things like brand names, trademarks, patents, copyrights, trade secrets, and more. These things may not be physically visible, but they represent value and ownership rights. Now let's understand some examples of intangible property. Nike's swoosh logo or the name Coca-Cola are also trademarks. While you can see the products that are shoes or soda, the logos themselves represent the intangible property rights held by companies. A book, music album or software is a work that is protected by copyright which is intangible. The text in a book or the code in a software program is intangible because you cannot physically touch it, but it still holds legal protection and value. The script of a movie or the lyrics of a song are intangible property, as you can listen to them, but they cannot be physically touched or owned like a tangible object. A new type of engine or drug formula can be patented. While you can see the engine or the drug itself, the idea or invention behind it is the intangible property that is protected by law. The patent gives the inventor the exclusive rights to use, manufacture, or sell that invention. The design and mechanism of smartphones are patented. The intellectual property, like how the iPhone functions, is intangible even though the product itself is tangible. A company's recipe for Coca-Cola or KFC's secret herbs is a trade secret. This information is intangible because it exists as a knowledge or a formula, not as a physical object you can hold. However, it has a tremendous economic value and can be protected legally. Google's search algorithm is a trade secret that is intangible. The actual code or process is not seen by users, but its effect is what is valuable. Britannia as a brand has built goodwill in the market due to the trust consumers have in the quality of their biscuits. This trust and reputation are intangible assets as we cannot see the goodwill of the company. Apple has immense goodwill, meaning its customers are likely to buy Apple products due to the brand's reputation for quality and innovation, even if some of the actual products are tangible. The design of a luxury car or the packaging design of biscuits can be an intangible property. The actual car or the biscuit packaging is physical, but the design itself is intangible intellectual property that is protected under design rights. Apple's sleek iPhone design and the shape of a Coca-Cola bottle are intangible properties related to their design rights. The physical objects are tangible, but the design as a form of IP is intangible.